Fuera con esto. Good morning. Thank you for being here. Thank you. Bonjour à tous. Bonjour à toutes et à tous. And good morning to you all. Let's get started because we get some points. Not too long, not too busy, but we got some points to go through. First, adopting the agenda. And I submit the changes to the draft agenda. First of all, LIBE Democracy Rule on Law and the Fundamental Rights Monitoring Group activities have been postponed. And instead, a new point was added to the draft agenda, which is Frontex evaluation report on return operations carried out second semester 2019. It will be reported later on. It's a point that we're having as a final point this morning. And then the announcements. First of all, interpretation. You know that there will be 8 languages in all. And the usual apologies for those languages not included. And the approval of the meetings, of course. If no objections, they are adopted. And then we go to the first substantial thing, which is a vote. Voting time by paper ballot. You know how it's like. We've got some practice by now. We have done it before. There is point 4, recommendation for a council decision, opening negotiations agreement between the EU and New Zealand for law enforcement cooperation, Europol, and fighting against serious crime and terrorism. The rapporteur is Annalisa Tardino. And I am here to remind you that members taking part in the vote will now receive functional mailbox, leave a vote, email informing the vote is opening now in 2 files. First of all, let's verify the quorum. I understand that we are to verify the quorum. Is it so?
Yes, we are. Not yet. We need to wait.
Okay, we'll wait.
They should push the button.
But anyhow, they have to push the button. Those of you who are remote, please push the button so that we know that you are alive. Yes, yeah, I see. Some of us. Let's hope that there will be quorum to have this vote. Do we? No, not yet. One more is needed. One more is needed.
One more is arriving.
Yeah, great, great, just in time. Thank you for showing hand. Thank you. Now we got the quorum. And so we are supposed to be starting the vote now. This Annalisa Tardino report on New Zealand EU agreement on law enforcement cooperation, okay? And the result will be announced as soon as possible. You know how the rules are for the remote vote. We're having some practice by now. But let's start with artificial intelligence in criminal law matters. And it's used by police and judicial authorities in criminal matters. We've got here a rapporteur, which is Mr. Kyoholaru, and he will be presenting his draft report for some minutes, let's say 7 minutes, and then we will be having shadows willing to react to the presentation of the draft report. And the scheduled time for this first point in the order of the day regarding artificial intelligence is half an hour. So let's see if Mr. Kyodaru is ready to break in the discussion. Are you ready to press the button, please, Mr. Kyodaru?
Press the speak button, please.
Make yourself present. Yes, there you are, Mr. Kyodaru. The floor is yours. The floor is yours. No, excuse me, we don't hear you. Would you please the mic? Please lower. No, excuse me. Raise the volume of the mic, or hello. Hi, Sophie.
Okay.
Mr. Kyodaru.
It's okay. You can hear me? You can hear me now?
If you raise the volume, we thank you for that. Press the speak button and of course the camera, if you will. The camera, if you may.
It's okay now?
I can hear you, but we don't see you now.
You can see me, you can hear me now?
Hear you, but we don't see you. So please, can we see you? The camera.
You can see me now?
We hear you, but we don't see you. The camera. Press the camera button in your
Press the camera button.
in your PC, please. Press the camera button besides the mic.
Press the camera button.
We saw you before. You made it. You made it before.
I made it before. Now it's good?
We don't see you. Can you do something with the camera? Put the camera on.
I have the camera on, but the device don't work with your system, I think. And they do the best we can. I think it's not my problem here. It's from the technique.
Okay, then if we can hear you.
Now restarting the system.
Okay, if you can hear me, I can.
Yes, now we see you and we hear you. There you are.
It's perfect, Mr. President. Have
Yeah.
a nice day. Okay. I can speak now?
Yes.
Ok. Mulțumesc, domnule președinte. Onorată comisie, cine renunță la libertate pentru o fărâmă de siguranță nu merită niciuna dintre ele, dar riscă să le piardă pe amândouă. Acest raport vine să răspunde unei provocări majore, iar motivațiile acestui demers sunt clare. Pe de o parte avem o tehnologie strategică, inteligența artificială, utilizată deja cu succes în multiple domenii, de la medicină până la meteorologie, iar pe de altă parte utilizarea acestei tehnologii în acest domeniu riscă să ne ducă pe un teren extrem de sensibil. Pentru prima dată acest raport pune în balanță beneficiile potențiale cu efectele și riscurile utilizării tehnologiei acestei inteligențe artificiale în dreptul.
Excuse me, Mr. Kildaro. Would you speak some slower, please? Some slower, because so that we can get you right, please.
Okay. I continue. Pentru prima dată acest raport pune în balanță beneficiile potențiale cu riscurile și efectele utilizării inteligenței artificiale în dreptul penal și de către autorități și oferă soluții și principii pentru ca această tehnologie de vârf să asigure siguranța pentru toți cetățenii. Cele trei principii pe care le-am enunțat și care sunt extrem de importante sunt cele care țin de siguranță, pe de o parte, cel etic și cel care prevede modalitatea de control în astfel de situații și insist pe faptul că factorul de control este extrem de important, decizia umană trebuie să fie controlabilă, iar potențialul de contestare a unor astfel de decizii trebuie să existe și să poată fi pus în practică. Iar soluțiile pentru a pune în practică aceste trei principii sunt cât se poate de clare. Pe de o parte vorbim despre transparență și recomand încă o dată ca acești algoritmi să poată fi verificați pentru a nu se duce la abuzuri sau la alte potențiale discriminări pentru cei sau asupra cărora se folosește această inteligență artificială, iar pe de altă parte de fiecare dată ar trebui să vorbim despre un studiu de impact și pe de altă parte de audit periodic pentru ca o tehnologie cu potențial benefic să nu se transforme în ceea ce nu ne dorim, într-o tehnică de supraveghere în masă. Tocmai de aceea, în finalul acestui raport, propunem un moratoriu pentru acea tehnologie, utilizarea acestei tehnologii în identificarea facială și credem că o dezbatere publică, inclusiv cu soluții găsite în această comisie, sunt opțiunea sănătoasă pentru ca acest demers să poată fi pus în practică. Revin la ideea de la care am început și cred că cine renunță la libertate pentru o formă de siguranță nu merită niciuna, dar riscă să le piardă pe amândouă, dar sunt convins că împreună cu dumneavoastră, onorată comisie, vom face ca inteligența artificială să poată fi aplicată corespunzător și în acest domeniu extrem de sensibil. Vă mulțumesc!
Are you done, Mr. Kildaro?
Yes.
Okay, thank you. Thank you. Now, we open the floor for the shadows. Getting started with Mr. Peters. Are you there?
Yes, I'm here. And I know the speak button also, Chairman. Okay, first of all, I would like to thank, of course, the rapporteur and his team for their work in drafting this. The file is an important one, given how much and how deeply artificial intelligence will change our society, including our law enforcement and judiciary. It is vital that we ensure that the values on which the Union is founded, in particular human dignity, freedom, democracy, equality, the rule of law and fundamental rights, are respected throughout the life cycle of AI tools, notably during their design, development, deployment and use. It is good to see that the rapporteur completely agrees with this goal. Some significant points, difference in approach remain tough and very important, and I shall mention 2 or 3 of them. First, I would like the report to mention the ban on AI-enabled mass-scale scoring of individuals that the Commission's high-level expert group on AI already called for. Especially within the field of law enforcement and judiciary, this would lead to the loss of autonomy. It would endanger the principle of non-discrimination and cannot be considered in line with European values. And I see no application where this technology brings added value to our Union. Secondly, unlike the rapporteur, I am not in favor of a moratorium on the development of facial recognition. It should be clear to all that facial recognition is a high-risk application and should therefore be accompanied by strong safeguards like data minimization, data accuracy, storage limitation, data security and accountability. Its use must be lawful, fair, non-discriminatory, transparent and following a specific explicit and purpose that is clearly defined in Member States or Union law. But I must remind everyone that today it's already used in an appropriate manner in several situations, for example, to search subject databases and identify victims of human trafficking or child sexual exploitation and abuse. I have also some other points, Mr. Chair and Rapporteur, but I think that we can finalize a very good report when we have this discussion and make some amendments very clear and approve them also, of course. Thank you.
Mr. Peters, we understand that the Renew shadow is Mr. Tudorache. Mr. Tudorache, are you ready to go? Are you there? Connected? Yes.
1 minute.
Press the speak button, please.
Press the speak button.
Press the speak button. Yes. There you are.
Can you see me?
Yes.
Yes. Excellent. Well, I would like to, of course, start by thanking the rapporteur, Mr. Ciuhodaru. I find the report balanced and aligned with many of the concerns that I have expressed several times in this committee when it comes to artificial intelligence. Of course, I think it's important to start by saying that this is a technology that is useful, that we have to continue to encourage because it has applications and use and benefits in many fields, in many domains of our existence, of our economies. But when it comes to law enforcement and judicial authorities, this is another matter, a matter where we have to be very careful. And I very much welcome again the approach taken in the report and also what has been already said by my colleagues. Both law enforcement and judicial authorities could of course benefit themselves from the potential benefits of tools, algorithms that can search, process large amounts of data and produce outputs that they could use in their work. And I think particularly when it comes to law enforcement, this is an evident use. But since both law enforcement and judicial authorities are working with human beings, are working with rights and liberties of human beings. Therefore, this is somewhere where we have to be very careful and where we have to be prepared to regulate very clear rules. I have been a judge myself at some point in my career, and I know that no machine, no matter how powerful or how sophisticated the algorithm, can replace a human being when it comes to ruling on a matter of the rights of someone. And that is why, again, I stress that in these particular areas, we have to be very careful. A lot has been said already about facial recognition, and I would maybe generalize a bit to the use of biometrics when it comes to what law enforcement does and how it can use artificial intelligence working with biometric data. And I also want to stress how careful we have to be to avoid function creep. It's true that there are, as the EPP shadow has said, Mr. Peters, it's true that there are uses for this technology already, but again, it is a very intrusive technology, and therefore, particularly each use by public authority has to be very carefully scrutinized. And I therefore, generally, when it comes to the use and deployment of artificial intelligence by state authorities, whether judicial, whether law enforcement, my plea is for very serious civilian scrutiny, for very clear rules on how we can verify that what is being done is aligned with our freedoms and liberties. I will stop here. Thank you very much.
Thank you, Mr. Tudorache. Now I will pass the floor to Green's shadow, which is Gwendolyn Delbos Corfield on behalf of Patrick Breyer. She will be taking the floor. Please mind that the scheduled time for the shadows to make the points is around 2 minutes. Try to stick to 2 minutes. Are you there, Mrs. Delbos? No, not connected yet. So we move to ID shadow, which is Mr. Van der Brische. Are you there? Connected? Nope. Then how about ECR shadow, Mr. Busadé? Señor Busadé, ¿está listo?
Sí.
Adelante.
Gracias, señor presidente, y por supuesto gracias también al ponente por el trabajo realizado. Efectivamente, un uso correcto y proporcionado de estas herramientas puede mejorar significativamente la seguridad de los ciudadanos en los Estados miembros, haciendo más eficaz la lucha contra determinados crímenes como el terrorismo, mejorando el control de fronteras, previniendo la entrada de criminales o la inmigración ilegal. No obstante, la variedad de nuevos sistemas que utilizan inteligencia artificial, como el reconocimiento facial, las tecnologías de lectura de labios, las herramientas de monitoreo de las redes sociales, sistemas de vigilancia autónomos y un largo etcétera, suponen efectivamente un reto para nuestras libertades y nuestros derechos, pues el riesgo de su utilización masiva por los gobiernos como instrumentos de vigilancia es altísimo y debemos impedirlo. Lo hemos visto en esta crisis del coronavirus, en que determinados gobiernos de izquierda en Europa han empleado los medios a su alcance para intentar obtener un control social masivo en el ámbito de las redes sociales. Y en este proyecto de informe se habla de ese monitoreo de redes sociales y, por supuesto, creo que debemos evitarlo. Por último, sería bueno que en la última fase de redacción se eliminasen algunas menciones de carácter ideológico para obtener un texto técnico adecuado que pueda ser también apoyado por este grupo, pues frente a las posibles intromisiones del gobierno, señor presidente, todos somos vulnerables y, por tanto, habría que eliminar esas distinciones de grupos sociales, económicos, raciales o sexuales que se anuncian en el informe, porque la vulnerabilidad de los derechos afecta a todos los europeos. Muchísimas gracias. Por ello es fundamental y sí que pues llamamos la atención del uso adecuado de los criterios de necesidad, proporcionalidad y transparencia, pero repito, evitando las distinciones de carácter ideológico, porque todos los europeos somos iguales con independencia de nuestro sexo, de nuestra raza o de nuestro color. Muchísimas gracias.
Gracias, señor Busadé. Now we move to GUE shadow, which is Cornelia Ernst. Frau Ernst, Sie sind bereit? Okay. Sie haben das Wort.
Vielen Dank. Ja, vielen Dank, Chair. Vielen Dank auch an den Berichterstatter. Ich glaube, das ist ein guter Bericht, an den man anknüpfen kann. Den können wir wirklich, wie es ein Kollege schon sagte, hervorragend machen. Und das ist auch unser Ziel. Ich will auch sagen, ähnlich wie andere Schattenberichterstatter, dass es natürlich kein Selbstzweck sein kann. KI bietet nun mal gewissermaßen geniale Möglichkeiten, wenn man so will, Menschen gläsern zu machen. Man kann zum Beispiel auch bei Fehlern, die auftreten, dann das hat sich ja zum Beispiel auch schon in einigen Ländern gezeigt, Menschen aburteilen, in Dateien stecken. Man kann praktisch sie zerstören, im wahrsten Sinne des Wortes, wenn ein Missbrauch hier passiert. Und deshalb sind die Grundrechte hier das alles Entscheidende, wenn wir über die KI sprechen. Es ist eben nicht nur eine technische Frage. Und ich möchte generell sagen, dass es wichtig ist festzustellen, bei den KI-Anwendungen, auch im Strafverfolgungsbereich, muss immer hinterfragt werden, was praktisch die ethische Frage, die sich dahinter verbirgt, ist. Es genügt nicht, dass wir es technisch einwandfrei haben. Es genügt nicht, dass wir versuchen, Fehlerquoten nur auszumerzen, sondern es ist eine ethische Frage, die wir uns hier stellen müssen. Und insofern ist es ein wichtiger Punkt. Das Zweite ist, wir müssen darauf achten, dass wir diese Diskriminierungsfreiheit tatsächlich realisieren und Massenüberwachung verhindern. Ich denke, es ist sehr, sehr wichtig, dass wir da bei Gesichtserkennung auch kritisch sind. Da meine ich ganz genau, dass wir diskriminierende Algorithmen verhindern müssen. Ich weiß gar nicht, wie man das perfekt machen kann und ob das Moratorium, das hier angesprochen wird, wirklich ausreicht, mit dem hier verfahren werden soll. Ich glaube, wir müssen einen klaren Punkt aufsetzen, indem wir sagen, Gesichtserkennung im öffentlichen Raum muss verboten werden. Auch das muss ganz klar nochmal hervorgehoben werden. Wir brauchen eine gesetzliche Basis, wenn wir über den Strafverfolgungsbereich sprechen, einen engen Anwendungsbereich, Rechtsmittel und vieles andere mehr. Und letztes möchte ich noch sagen, wir müssen diskutieren, wie wir zu Pre-Crime-Software stehen. Ich halte es für unerlässlich, dass diese Debatte geführt wird bei uns, weil hier natürlich etwas passieren kann, präventive Verhaftungen, präventive Beobachtungen in den sozialen Medien und so weiter, was damit natürlich eng zusammenhängt mit KI und uns die Frage stellt, wollen wir das? Wie gehen wir damit um? Wir halten das für hochgefährlich. Vielen Dank.
Danke vielmals. Now, let's see if the shadows that couldn't make it are now ready to go. Is there any one of them connected? Mr. Van de Briche or Mrs. Wendelin Delbos Corfield? Should you be ready to make your points? Are they connected? Any signal? Nope. Nope. If they are not connected, then we move on, because we still have a couple of members who have shown, raised hand to make a point. Please do, Mrs. Infeld.
Yes, thank you, Chair, and I would like to thank the rapporteur. Just a general remark, because whenever we're passing legislation, we tend to be a little bit academic and not, we seem to ignore how laws are applied in practice. When we're talking about the use of facial recognition, for example, for law enforcement purposes, I note that that is already being used by police forces, despite the fact that the national and European supervisors consider that it is a possible breach of data protection rules. There is notably a company called Clearview, which is offering facial recognition services and a search function, which apparently is being used by police forces. And the point is that if we are passing legislation, but we find that law enforcement agencies are not open and transparent about the use they're making of this technology, when they're not honest, when we cannot verify as citizens whether they are actually respecting the law, then I think our legislation is not effective. So I think we need to take this into account when we're passing laws. We also have to have effective means of enforcing it, of holding law enforcement agencies to account, of being able to verify. what's happening, and I think that needs to be a very strong component, transparency, accountability and enforcement. Thank you.
Thank you. I understand our colleague Franco Roberti vorrebbe anche dire qualcosa in collegamento. Onorevole Roberti?
Mi senti?
Sì, proprio lì.
Ci sono? Buongiorno, grazie Juan Fernando. Io sono relatore ombra nella Commissione Giuri sul tema dell'intelligenza artificiale, quindi vi perverrà il parere che stiamo formulando. Credo che daremo un contributo significativo al lavoro del relatore in questa Commissione e di tutta la Commissione. Ora mi limito a illustrare brevemente alcuni punti che tengo particolarmente a cuore. Innanzitutto siamo d'accordo tutti, è stato anche detto prima in un altro intervento, che nella fase giudiziaria, sia civile che penale, l'algoritmo predittivo può essere un supporto utile alla decisione di un giudice, del giudice essere umano, ma non potrà mai sostituirsi ad essa. La valutazione della prova, sia in sede civile che in sede penale, specialmente in quest'ultimo caso la prova di natura indiziaria, è un'attività intellettuale irriducibilmente umana, che non potrà mai essere surrogata da un algoritmo. Ora, venendo con riferimento al paragrafo 7 del draft del collega Ciodaru, a mio avviso è necessario ancorare l'utilizzo dell'intelligenza artificiale al rispetto delle linee guida fissate dalla Carta Etica del Consiglio d'Europa. Sono principi ben noti e non sto a ripeterli, ma mi limito a ricordarne uno: garanzia del controllo umano da parte dell'utilizzatore. Aggiungerei anche un altro fondamentale principio, quello della indipendenza del giudice come presidio di uguaglianza dei cittadini di fronte alla legge, fondamento dello Stato di diritto. A questi principi, secondo me, dovranno attenersi, e noi dobbiamo dirlo nel nostro report, dovranno attenersi i soggetti pubblici e privati responsabili del progetto iniziale e dello sviluppo degli strumenti e dei servizi dell'intelligenza artificiale, affinché sia possibile da parte di tutti gli attori del processo civile e penale un pieno controllo dei processi, diciamo, dell'intelligenza artificiale, dei procedimenti decisori. E poi quindi indispensabile prevedere, secondo me, una norma che istituzionalizzi il principio di indipendenza dei programmatori, dato che sono i programmatori che predispongono non solo la selezione dei dati e delle informazioni alla base degli algoritmi, ma anche i criteri di valutazione che strutturano e producono una decisione. Inoltre è necessario elaborare specifiche norme di condotta inderogabili per i soggetti pubblici e privati responsabili della progettazione e dell'utilizzo dell'intelligenza artificiale, non esclusa la richiesta di assicurare la massima trasparenza negli assetti societari di queste società che creano e gestiscono i sistemi di intelligenza artificiale. Mi avvio a concludere segnalando un ultimo punto. Spostando l'attenzione all'ambito strettamente processuale con riferimento al diritto di difesa richiamato nel paragrafo 2 del report, non dovrebbe mancare, secondo me, un richiamo al diritto delle parti di accedere al processo di raccolta dei dati, di valutazione prognostica funzionale alla polizia di prevenzione, di catalogazione e valutazione delle prove penali e di valutazione della pericolosità sociale dell'indiziato e del rischio di recidiva. Anche se in quest'ultimo caso, il caso di valutazione della pericolosità della recidiva, il giudice potrà trarre ausilio soltanto da un algoritmo non viziato da pregiudizi o stereotipi in sede di programmazione. Ecco, questi sinteticamente sono i punti che formeranno oggetto degli emendamenti da noi suggeriti e che faremo pervenire nei termini prescritti. Grazie e buon lavoro.
Grazie, onorevole Roberti. Now we move to hear from the Commission. I understand Director Onidi. Monsieur Onidi, vous êtes là? Vous êtes prêt? Monsieur Onidi, de la Commission.
Speak button, please.
Il y a un problème?
Press the speak button again.
Speak button. Speak button. Il marche? Le micro. Merci. Merci, Monsieur Onidi.
Press the speak button.
Well, very good to see you back in Brussels, Chair, and I hope we'll be able very soon to be back in the room with all of you. No, thank you for just a very short intervention on our side, essentially to thank all those, the rapporteur of course, but all the others who have contributed already to this report. It's an important report because it's an important subject. It's a difficult subject, and you've mentioned it. But it's also a subject in the context of the consultation that is ongoing, which was lacking actually a major contribution specifically targeted at law enforcement and judiciary use of artificial intelligence. And to that extent, really, this draft report is immensely helpful. We believe it is important since we see criminals more and more using technologies, including artificial intelligence. And I think it is our responsibility to equip the law enforcement and also our judiciary with at least similar and even better tools than criminals have. But we also see that artificial intelligence allows us to better target what is being done, the type of data that is looked at, the type of information that is also analyzed, to those that put a risk to our society. So this is, I think, a very precious tool to help us to progressively leave, the general kind of data analysis with more targeted approach, which are also helping out very much to respect personal privacy, but also fundamental rights in general. We also see that member states are actually advancing in not only implementing artificial intelligence in the judiciary and the law enforcement sectors. So I believe the EU has now an opportunity and also a role to play in order to make sure that all these national initiatives are actually not only respecting fundamental rights and overall legislation in terms of privacy, etc., but are also geared at being as effective as possible. And then finally, we believe that it is absolutely essential that we develop this framework here in Europe in order also to develop European solutions that will be used by our police, by our judges, by our prosecutors, instead of having them use technology and solutions that are being produced outside in China or other places. Finally, many of you have hinted at a possible framework. We believe at this stage that we would not necessarily have to develop a specific legislative framework for the use of artificial intelligence by the law enforcement and judiciary authority, but we need to be extremely vigilant, and Ms. Intervelde and others have said it, that this is being done in full respect of what exists already, the Charter of Fundamental Rights, the GDPR, etc. In that context, the Parliament's research services have issued a report a week ago where they clearly explain how the GDPR framework is actually very much conducive and compatible with the use of artificial intelligence, and that the main issue is not to come up with a new framework, but rather possibly some adaptation and certainly guidance. And I think the discussion you've had earlier this week with Commissioner Renders on the very useful role of the Commission's guidance for tracing application in the context of COVID might be there also an illustration of the type of value added that we could come with very quickly in order to already pose the essential signposts where possibly for artificial intelligence is being used. So not necessarily full and new legislation, adaptation may be of certain aspects, and certainly a lot of guidance, a lot of vigilance while this is being rolled out. We're not sure also of the moratorium. This is one aspect that is being debated in the consultation. We believe it's better to use, and by the way, and some of you have said it, facial recognition is used by a number of authorities. Rather look at this and frame it again so that it is not, something that goes against fundamental rights, rather than dictate a moratorium which might cut us off from very useful experience. Thank you immensely for this debate, and thank you for having us with you today.
Well, thank you, Monsieur Onidi. Now, before turning back to a final concluding remark, which is expected to be real short, we have noted that Monsieur Delbos Corfield is now connected. Could you make it in 1 minute, please, Monsieur Delbos Corfield, because we are exceeding the scheduled time for this point, and we're having another point and then a debate on Frontex. Please. Yes, there you are. There you are. There you go. Please make it short.
Can you hear?
Make it short.
Yes, okay, sorry. Sorry for this. Look, well, I think most of it has been said, so we wanted as Greens really to insist on the fact that all of this should always go hand in hand with legal framework and human oversight, but that has been plenty times said already. We really took the example of the LIBE Committee delegation that was in the United States in February, and heard both from Cambridge in Massachusetts and New York City that they had phased out from their predictive policing programs because they were seen to have significant discriminatory and racist biases. And then we know that Chicago and Los Angeles did too. So I think that these examples are very clear examples of how we should be very careful with all these systems. But once again, it was said by most of my colleagues already a lot.
So much. Now we're back to you, Mr. Kyodaru, please, to final concluding remarks. If you may, are you connected again? Can you make it? Yes, final point, Mr. Kyodaru.
Madam, can you see me? Can you hear me? Hello? You can hear me?
Yes, we can hear you, we can see you. Go.
It's good. Doar legile divine sunt perfecte, restul sunt perfectibile, dar cred că astăzi am făcut un pas important în ceea ce înseamnă utilizarea inteligenței artificiale și stabilirea principiilor și modul în care le punem în practică. Nimeni nu-și dorește, și eu sunt medic de urgență și acum sunt la Iași, la Spitalul Clinic de Urgență Nicolae Oblu, ca drepturile fiecărui cetățean european să nu fie respectate, și sunt cel care combate de fiecare dată și Ministerul Adevărului și tot ceea ce este menționat în acea celebră carte 1984. Tocmai de aceea facem un raport cât mai echilibrat și ați văzut că am toată disponibilitatea de a prelungi termenul de
It's been cut, Mr. Kyodaru. Can you reconnect? Something happened. Yes, there. Make it final. Can you make it final, please?
Sper că împreună vom reuși să facem acest raport să dea un moment de răscruce, pentru că de inteligență artificială pe de o parte avem nevoie, iar pe de altă parte avem nevoie ca această inteligență artificială să nu afecteze nici măcar puțin drepturile cetățenilor europeni. Vă mulțumesc!
Thank you, Mr. Kyodaru, and that'll do for this point. Let's move ahead to the following point. Thank you so much for your contribution. Good work at the hospital. There you are. Now let's move to the following point, which is implementation of the Return Directive. There you are. This is a sensitive issue. And we've got as rapporteur for the matter our colleague, Mr. Tineke Strick. But I understand that in order to present the case of this Return Directive, there will be a presentation from the Research Service of the European Parliament. It will be delivered by Dr. Isabella Matcher. Dr. Isabella Matcher, is she connected? Is she connected? So that we can hear from her, and then we will be hearing from our rapporteur, Mrs. Tineke Strick, and some members which are also listed to take the floor. But let's see if, yes, Isabella, there you are. I understand that you are a researcher specialized on EU migration, asylum policy, focused on the Return Directive, which was much discussed and argued about in this European Parliament, still pending on the review of this return directive in the context of the new Pact on Asylum and Migration. And if you make it in 5 minutes, 6 minutes maximum, please help us to catch up, because there are a list of members which are also willing to contribute. The floor is yours.
Good morning. Can you hear me?
Yes.
Can you hear me talking?
We hear you, we see you. There you go.
Okay, great. Thank you very much. Good morning. Distinguished Chair, members of the LIBE Committee, ladies and gentlemen. It's a great pleasure for me to present the study on the implementation of the Return Directive, and I wish to thank the committee for this opportunity. My presentation will be, of course, brief and will touch upon the Part 2 of the European Implementation Assessment of the Return Directive published by the European Parliamentary Research Service. My presentation will briefly discuss the objective of the study, the material and geographical scope of the study, and a few key findings. I won't have time to discuss more the methodology used or the policy recommendations, but you have them on the slides, and we can get back to it during the Q&A part of the session. So in terms of the objective of the study, the European Commission issued a report on the implementation of the directive in April 2014, and since then the Commission has not reported on the directive. In this light, the objective of the study was to assess how the Return Directive is implemented at the domestic level. The study was based on 29 sets of research questions, and they were grouped under 4 main headings, which also represent the 4 key measures established under the directive. And these are 1, the return decision; 2, the implementation of the return decision; 3, entry ban; and 4, detention. The study covered 10 EU member states, and these were Belgium, Bulgaria, France, Germany, Greece, Italy, the Netherlands, Poland, Spain, and Sweden. With 10 states covered, the study actually covered 1/3 of all the countries implementing the directive, so the geographical scope was extensive. Now, let me now look at a few key findings of the study. I have selected 10 sets of findings, and we present them according to these 4 key measures, which I just enumerated. For the remaining findings, I invite you to have a look at the report. So, number 1, as regards the return decision, the study shows that the risk of absconding is rarely assessed by the authorities on their own motion before the start of the return process. This may relate to the fact that the directive does not contain an explicit non-refoulement exception to the obligation to issue a return decision. In addition, there is an assumption, I would say, that refused asylum seekers had already the refoulement risk assessed during the asylum process. However, such a procedure will typically only assess the conditions for granting the refugee status or the subsidiary protection status. Number 2, unaccompanied children are rarely returned, but there are just few countries which have an official policy banning return of such children. Number 3, as regards the implementation of the return decision, voluntary departure is prioritized, but in law or in theory. In practice, the 3 grounds on which states may refuse it or shorten the period of voluntary departure are broad and may cover the majority of cases. Number 4, in terms of entry ban. Entry ban is typically imposed automatically along when voluntary departure was not granted or was not complied with. In some countries, however, it is imposed even alongside voluntary departure, which may actually reduce the incentive for the person to leave the host country. Number 5, the entry ban involves costs, so its efficiency should be considered. Number 6, there are no comparable and disaggregated data on the use of entry ban. Now, as regards detention, finding number 7, detention is in practice based generally on the individual assessment. However, it is quite easy to justify detention because of the wide legal basis. This also relates to the fact that countries have typically long and sometimes even non-exhaustive lists of criteria for establishing the use of absconding. Number 8, states provide for alternatives to detention in the legislation, but these measures are generally rarely applied in practice, and one of the reasons might be the wide understanding of the risk of absconding. Number 9, in several countries, detention of unaccompanied children is prohibited, but those children may still end up in detention because of an inaccurate age assessment. And number 10, the last finding, like in case of entry ban, there are no disaggregated and comparable data on the use of detention, so it's actually impossible to assess the impact of detention on the effectiveness of return. Let me now just briefly conclude. The study discovered several promising practices, such as rare cases of the return of unaccompanied children, prioritization in law of voluntary departure, or the use of dedicated detention facilities. However, the research also shows that there are still existing protection gaps. For instance, rare instances of the assessment of the risk of refoulement on authorities on motion, rare cases of automatically suspensive effect of return, or the wide understanding of the risk of absconding. Thank you very much for your attention, and I'll be happy to answer your questions.
Thank you so much, Dr. Majek. It's been great help. Now let's move directly to the rapporteur and the shadows. The rapporteur is Mrs. Strick. The floor is yours.
Thank you, Chair, and also thanks to Mrs. Macho for her presentation and for the report that she has released and drafted. I must say, when I dove into the implementation research on the Returns Directive, it became clear that we really have a lack of information. We have a lack of proper implementation reports. The last implementation report dates back to 2014, although the European Commission is obliged to do an implementation research every 3 years. So we lack information and evidence, and that was actually also the reason for the European Parliament to say, okay, then let's do it ourselves, because we now have the huge task to have our contribution to the recast proposal, and therefore we need to know how the current rules are being applied and what is the exact problem if it comes to effective returns and safeguards. But, of course, the EPRS study can only be limited. I mean, it cannot replace a full-fledged Commission evaluation, so we still call upon the Commission to do so. We have a limited scope in terms of numbers of countries, and we also faced problems in getting the right data from the Member States, because the Member State took the position that it's up to the Commission to do the research. So there we come in a catch-22 situation. Nevertheless, I highly appreciate the efforts of the researchers and also the result, because we really have a report that we can learn from and that give a very good insight on how Member States deal with the rules on the Returns Directive. I think it's very important that the research took a qualitative approach, because until now there's a lot of focus on quantitative issues like the return rates, but the return rate doesn't say anything about the factors, the success factors or fail factors, so we don't learn a lot about it. And besides, the Returns Directive also have other objectives, mainly also to ensure procedural safeguard and the principle of proportionality. And there the return rates do not help us anyhow. So we really wanted to see how the rules and the proportionality principle are being applied, because that should also be part of the effectiveness research.
And our finding is actually that this effectiveness is very much hampered by the big number of optional clauses, so possibilities for member states to derogate from the main rules. And we see that, for instance, with voluntary return, whereas voluntary return has to be prioritized throughout the return process, but as the voluntary departure terms can be reduced or even deleted in a number of cases, you see that many member states use those options to do so, and therefore sometimes really no voluntary departure term is more or less the rule instead of the exception. And this means that it's very difficult for people to voluntarily return, and even more, the problem is then that an entry ban is being imposed. And it mainly means that it's actually discouraging people to depart from the country, especially if it is imposed at the moment that you still have a voluntary return term. And that seems to be the case in many member states. But why should you leave the member state voluntarily if you know that you cannot re-enter anymore, so that there's no reward, but actually that you're punished by leaving voluntarily? We really think that this is a flaw in the directive and that member states should not impose an entry ban at the moment that there's still a voluntary return term applicable. So I think that here you have really problems with both proportionality and also effectiveness. And the same is what we see with detention. Detention should be the last resort. It's clearly also expressed in the directive. But if you want to apply it as a last resort, you really need to have alternatives in place. And you see that many member states do have it in the legislation, but do not make it available in practice, let alone that they really apply it in individual circumstances. So in that way, detention more or less becomes more automatically the rule instead of the exception, the last resort, especially while the risk of absconding that are being used in practically all the member states are very broad and generally formulated, and there's also no framework and no really individual assessment applied at that moment. The main principles of the directives on non-refoulement, best interests of the child, family life do not seem to be applied very effectively and not on an individual base. And maybe the best example of that is that many children are still held in detention in many member states. Although we all know from a lot of research that detention is never in the best interest of the child. Well, to conclude, Chair, I would like to stress that the directive is often blamed for impeding, for being an impediment for returns. We did not find any evidence for that. But what we found is that other factors that may play a role in not effective returns are absent in the discourse. And for instance, these are much more external factors like cooperation with countries of origin. On the other hand, there could be much more harmonization than we see now if the derogations in the Returns Directive would be really applied as exceptions and that we would really stick to the more general norms that are established in the directive. And finally, to conclude, we would really call upon the Commission to pay much more attention to the proportionality principle, to the procedural safeguards, as this was really just as important as effective returns when the directive was established. And you should bear in mind that coercion measures always touch upon fundamental rights, and they need to be justified properly. And then the directive also has a provision on monitoring, I would really call upon the Commission to make more work of the monitoring. Make sure that there are monitoring bodies in place which are independent, which can work transparently and have a proper mandate. In many countries, this mandate is being restricted, and the Commission should be very, very vigorously protecting their mandate and their rights and competences. Because we see in many cases, especially in the pushbacks at the border, where this is again an issue that the Returns Directive allows for not applying the directive at the border regions, but still I think that the Return Directive could play a much bigger role if it comes to avoiding and pushbacks and enforcing member states also at the border to comply with the rules. Thank you very much.
Thank you, Ms. Strick. Now we move to the shadows. So please try to stick to the 2 minutes time each, if possible. We start with the EPP shadow, which is Paulo Rangel. Floor is yours.
Okay, I wouldn't say that it is possible, but we cannot do the impossible. And so I'll try to stick. But it's very difficult to discuss such a matter in 2 minutes, as you can imagine. First, I would say that we don't lack so many information. And even the study, I'm a bit critical of this research study because it has a lot of self-references, but not really when we have Europol, European Migrant Smuggling Annual Report, the EASO Annual Report, the evaluations of the Schengen Evaluation Mechanism on return, the Frontex Evaluation Report on return operations. We have too much information that we could use, and it is not used because in a certain way the conclusions are already taken in this study before they are based on evidence. Second, I must say that without a credible policy of return, we are not going to be able to defend and to protect the people that really need protection. And this is something that is very important. I wouldn't do what I see that the rapporteur, that I want to salute and welcome her work, but says that is that we need a qualitative approach. No, we need more quantitative approach with disaggregated data. That is the point. But not these subjective things, where we say things like this, that is really astonishing, when we say that entry bans may discourage people from leaving. But this is really fantastic. If you have a return decision, you have to have an entry ban. This is clear. Because, of course, if you have a return decision and then you can come again, of course you are going to return and come and return and come. So this is really against the empirical evidence. This is a political and ideological prejudice that is here. And so what I'd like to say is that even in the Malta Declaration, that our S&D and Greens group so much like, it is, I quote, written, an effective and quick return is important. And thirdly, I also would like to say that our scope should be exactly the implementation of this directive and not to draw conclusions to the recast of the directive, because we have a parallel process of another report. And there we can discuss the policies. Here we should stick to the implementation. Let me say that only one example, and I will conclude, but it's only to give one example. For instance, this idea of ex officio examination. Let me see. I can agree that you can have an ex officio examination on legal framework to say, okay, they have torture, they have inhuman treatment or inhuman punishment. Okay, but you cannot know if someone is a Muslim or is persecuted or is under threat if the he or she doesn't apply. This cannot be seen ex officio. You cannot look at a person and say ex officio, I'm going to see if you are persecuted. This is impossible. Sometimes people, what I see in these kind of studies is that you see a kind of a principle without going to the reality, to see what happens in the reality. When you apply, you say, you have a return process that is being, I'd say, done, and of course you cannot, the person that is under this process, he or she, they have really to say what they want to say in their own defense or his own defense. We cannot do it ex officio. Of course, I can say ex officio, I can see the legislation. But if there is a practice of torture, there is no policial authority and there is no judicial authority that can do it. So it has to be invoked by the person. It's not ex officio. And please, the process of asylum, if it was denied, is a good basis to assess the non-refoulement. Of course, it's not complete, but it's a good basis. And it should be taken also in account. We should not duplicate the work of the authorities. So I would say we should be quite sensible in this. And so to protect the rights of the people, but not to have here ideology, because at the end of the day, it will be the people that are in need that will be prejudiced by this kind of ideological approach to quite objective reality.
Yeah, we understand this matter is sensitive, and this debate will be followed by another one which is much related, the Frontex operations, return operations by Frontex, which will be presented by the person in charge in the agency by Frontex. But please try to be as concise and sharp as possible. Now for the S&D, ça va être Madame Guillaume. Nous vous écoutons.
Merci, Monsieur le Président. Ce qu'il faut bien redire, c'est qu'aujourd'hui, on fait un travail que la Commission aurait déjà dû faire. Le seul moment où ce travail d'évaluation a été réalisé, c'était en 2014. Il aurait dû y avoir 2 autres évaluations depuis, et elles n'ont pas eu lieu. Et je trouve que les justifications qui ont été données pour ne pas avoir eu ce retour ne sont pas tout à fait satisfaisantes. Et d'ailleurs, je note que, comme c'est le cas dans d'autres dossiers, non seulement il n'y a pas de rapport de mise en œuvre, mais il n'y a pas eu non plus d'études d'impact. Donc c'est quand même des traits assez lourds. Et je trouve que bien légiférer en la matière, s'agissant de questions humaines comme ça l'est, et pas seulement quantitatives comme on voudrait nous le faire croire, ça ne rend pas les choses très simples. Donc heureusement, il y a cette étude qui a été menée. Et je remercie, moi, le PRS de l'avoir fait. On notera énormément d'éléments dans ce rapport. J'en tire quelques-uns sur l'effectivité des retours. Là, on a une approche par les États membres qui est basée sur les taux de retour et non sur la durabilité de cela. Dit autrement, on s'intéresse au nombre et pas au fait que le retour se concrétise après avec des personnes qui restent sur place ou bien qui sont tentés de revenir. C'est là où ça s'oppose à la logique que vient d'exprimer M. Rangel. Dans cette étude, on montre aussi l'intense disharmonie entre les États membres, voire des incohérences dans leur fonctionnement. On montre aussi et on voit combien la détention ne permet pas clairement d'augmenter le nombre de retours. Et puis, ça montre aussi clairement le flou juridique dans lequel un certain nombre de personnes se trouvent. C'est-à-dire qu'ils ne peuvent pas être renvoyés et ne peuvent pas rester. Donc, une espèce de limbo complet pour les personnes concernées. Et puis, il y a donc effectivement ce retour sur l'approche qualitative plutôt que quantitative en matière de retour. Donc, tout cela est très important et va nourrir un autre travail qui sera mené et le rapport de Madame Strick, sur lequel je pense qu'il faudra qu'on apporte un certain nombre de clarifications en ce sens. En tout cas, c'est le travail que mon groupe et moi-même mènerons à vos côtés. Merci beaucoup.
Now for the renew, it'll be Sophie. Excuse me. Yes, in the belt. Yes.
Okay, no other Sophie? Okay, thank you, Chair. I would like to start by thanking the rapporteur for doing a very good job, because I think what she is doing is actually what we should be always doing, and that is doing evidence-based policy making. And I'm a bit surprised to hear the EPP accuse her of being ideological, whereas this is actually the first example of somebody making a very serious attempt at collecting the facts. what has been said about the process, I fully subscribe to what has been said by the rapporteur and by Mrs. Guillaume. Basically, what the European Commission should do is collecting the facts. But sometimes the facts don't suit the political wishes of the Council, and then the Commission just skips that step. And if the Commission had done its job, then we would probably not be in this situation, and we might not even be talking about a recast of the Returns Directive, but actually a better implementation of the Returns Directive. Yes, Mr. Rangel, because the problem here is that the existing rules are not being applied properly. That is the problem. It's not a problem that there is insufficient detention, that we don't lock enough people up, or that there is that we need entry bans. The problem is that very often people cannot be returned because there is, because of the relations with the third country. That is the problem. You want facts, you don't want ideology, then recognize the facts. So, and as Mrs. Guillaume has also said, what is important is not just the rate of returns, but also the quality of returns, because that actually ensures that people want to stay rather than come back. An entry ban is not what's going to keep them out. And we have seen, for example, the reports on the returns of children to countries like Afghanistan, which was a bloody disaster. That is a fact. That's not ideology, Mr. Rangel. That's a fact. And I can tell you from my own country, people have been returned against the recommendations of the experts, then to find themselves imprisoned, tortured, or killed for political reasons. And when you're talking about ex officio assessment versus individual assessment, I very much agree with you, and I hope that you're also going to apply that principle when we're talking about, for example, the principle of safe countries versus individual assessment. So don't talk about ideology, EPP. We all know that the sustainable returns are the voluntary returns, so that is something that we should be investing in. We should be investing in monitoring, reintegration, the position of children. We should be investing in relations with third countries and making sure that they are cooperative when it is about returning people. When it comes to the risk of absconding, I feel we should have a very but this is of course recast of the Returns Directive. We should have a strict definition, because quite frankly, if I see how some of the member state governments are interpreting European law and international law, and very often just disregarding international law, most recently again Hungary, the Hungarian government, not surprising. Speaking of ideology, then I think we should have very strict and clear rules and not give too much room of maneuver to member state governments, because they simply cannot be trusted to respect human rights. So my support to the work of the rapporteur. Thank you.
Now for ID, it'll be Nicholas Bay. Nicholas. Yes, Nicholas Bay, no?
For ID, we don't have a name.
But not connected, but then let's move to ECR, Mrs. Kempa. Mrs. Kempa? Yes, please.
Thank you. Sprawa jest bardzo poważna i myślę, że w tej sytuacji powinniśmy usiąść. Jest kilka dokumentów, które już w tej chwili są w toku procedowania. To jest nie tylko kwestia paktu azylu i migracji, to jest też dyrektywa powrotowa. One muszą powstawać, czy te nowelizacje, w wielkim szacunku dla przede wszystkim też krajów członkowskich i dla podejścia ich społeczeństw do kwestii migracji. Ale faktem jest, że sytuacja jest coraz bardziej trudna i napięta. Ostatnie obrazki z Lampedusy pokazują, że w sposób już niekontrolowany docierają w tej chwili do Lampedusy coraz większe ilości imigrantów. Głównie w tej chwili, na ten moment, według ostatnich informacji z Libii i z Tunezji. I my musimy się zastanowić nad jeszcze jedną kwestią, mianowicie być może nad zmianą filozofii. Ja nie mówię o ideologii, zostawmy to, ale filozofii podejścia czy sposobu podejścia Unii Europejskiej do kwestii migracji. Dlatego, że jeżeli Prawdą jest, jeżeli tak się stanie, że w nowej perspektywie finansowej środki na pomoc rozwojową i pomoc humanitarną będą ograniczone, ja nie wnikam w przyczyny, ale mogą być zmniejszone, no to co w tym przypadku z kwestią związaną z tak zwaną pomocą na miejscu, czyli ograniczaniem fali tak zwanej migracji zarobkowej, ekonomicznej do Europy i w jaki sposób będziemy mogli, a to jest jedyny sposób na przeciwdziałanie niekontrolowanej migracji, temu co dzieje się w tej chwili we Włoszech. Ja tutaj Włochów wspieram w ich działaniu i absolutnie rozumiem, ale podobnie rzecz się ma w tej chwili w Grecji z przenikaniem uchodźców z Turcji do Grecji. Te obrazki, które widzieliśmy również w mediach na granicy turecko-greckiej są faktem. I nie możemy zamknąć oczu i mówić tylko o kwestiach prawa człowieka, bo trzeba o tym mówić, ale jak się to ma do praw człowieka, skoro sytuacja ekonomiczna zmusza tych ludzi do tak karkołomnych decyzji, jak zapłata przemytnikom i przejazd łodziami, przepływanie łodziami do bram Europy. I jakkolwiek byśmy nie wzmacniali Frontexu, jakkolwiek byśmy tutaj głośno nie krzyczeli, że jesteśmy otwarci, to jednak mamy potężny problem. Otwórzmy oczy. Mamy potężny problem. I z tym problemem jakoś nie widać na horyzoncie rozwiązania tego problemu. A jeśli do tego jeszcze dojdzie fakt, że będziemy ograniczać pomoc rozwojową i humanitarną, to będziemy mieli potężny kolejny problem. Dlatego, że w tej chwili z tego co wiem, z moich osobistych również kontaktów, zarówno w Syrii, jak i w Libanie i w Sudanie Południowym jest potężny problem związany również z koronawirusem. Musimy to brać też pod uwagę. I dlatego, szanowni państwo, jeszcze raz powtarzam, problem jest bardzo poważny i nie może pozostać na poziomie dyskusji akademickich, tylko powinien być na poziomie bardzo konkretnego działania na dokumentach, w którego dyspozycji jest Unia Europejska. Dziękuję bardzo.
For the GUE, it'll be Madame Pelletier.
Bonjour à toutes, merci Monsieur le Président, merci Madame la rapporteure et un grand merci aussi à l'étude de l'EPRS. Alors, cher Tineke, on voit dans l'exposé des motifs tout ce que vous soulevez comme enjeu et problématique de cette directive. Et on y voit surtout votre engagement et votre humanité. Alors, un grand merci. Je vais rappeler quand même une position historique de la GUE qui était opposée à cette directive retour. Pourtant, néanmoins, force est de constater qu'elle a permis de limiter les atteintes aux droits fondamentaux dans de nombreux États membres, mais rappelons que ces droits font l'objet d'attaques incessantes de la part des États membres et de la Commission européenne. Je partage nombre de vos recommandations, Tineke, et la première étant que nous avons un besoin urgent d'une évaluation au point de vue quantitatif, d'accord, mais surtout au point de vue qualitatif. Je voudrais insister sur l'adjectif qualitatif. Vous avez également mon soutien en matière de rétention, qui a été pensée à l'origine comme une, finalement, dernière mesure, la dernière des dernières. Et si elle est nécessaire, je voudrais rappeler qu'elle doit être proportionnée, raisonnable, et que sa durée doit être la plus courte possible. Alors qu'on constate qu'aujourd'hui, ce n'est pas le cas, parce que si, chers collègues, vous allez visiter des CRA, vous vous rendrez compte que la durée de rétention est particulièrement importante et souvent systématique. J'ai également une pensée pour les enfants, groupe ô combien vulnérable et dont la protection de leur intérêt supérieur doit être notre priorité. Vous insistez, Tineke, à plusieurs reprises sur ce sujet et vous pouvez compter sur mon soutien plein et entier pour mettre un terme à la rétention des enfants dans l'Union européenne. Alors après, je partage l'essentiel de ce rapport. Et dans nos amendements, nous mettrons l'accent sur la possibilité aussi offerte aux États membres d'accorder un titre de séjour aux personnes faisant l'objet d'une décision de retour. Parce que je voudrais particulièrement penser à ces travailleurs travailleuses sans papier, comme ces personnes à Chronopost à Alfortville ou ces livreurs à vélo de Frichti. Nous insisterons également sur les personnes qui ont été déboutées de leur demande, mais qui ne peuvent pas être renvoyées du fait du principe de non-refoulement. Ces personnes, nous devons les protéger en ne les renvoyant pas dans des pays où elles seraient exposées à des risques importants et que nous dépossédons finalement de tous leurs droits. Ces personnes qui sortent du cadre légal finissent sans papier dans une indifférence générale et l'application de la directive a créé cette nouvelle catégorie de sans-droits que nous devons protéger et inclure. C'est notre devoir d'humanité. J'ai une dernière interrogation, mais vraiment, nous pourrons en rediscuter. Vous insistez sur les garanties procédurales, et pour moi, c'est très bien. Je voudrais simplement qu'on s'assure que ce soit bien des retours volontaires, et que ce soit garanti en retour volontaire, et non des retours qui seraient forcés, et où on nous dirait, puisque nous avons eu des témoignages quand même d'ONG, où on nous dirait que finalement, ils étaient volontaires et ils ne l'étaient pas vraiment. Donc vraiment, cette notion, est-ce que c'est vraiment un retour volontaire? J'aimerais qu'on puisse aussi aller un peu plus loin. Merci Tineke en tout cas.
Madame Pelletier, I remind you that we are exceeding our timing and lagging behind, and we have a director of Frontex scheduled by now, but we still have some points to be heard. First of all, maybe a 2 minutes reaction from Dr. Metzer. If she's there, Isabel, from the research service, would you like to react shortly to what you have just heard before turning back to our rapporteur, Mrs. Strick, and maybe the Commission too? I understand the director of the Commission will also be liking to contribute to the discussion. Isabella, are you there? Yes, please. Can you react shortly?
Right. I will quickly respond to the questions of Monsieur Rangel. Thank you very much for your questions. Actually, you invite me to address something that I didn't have time to look at during my short presentation, the methodology of the study. The study was a study of the implementation at the domestic level, and the methodology was supposed to be based on the information coming from the member states. The initial methodology was based on the questionnaire sent to all the member states covered. However, one member state decided to fill out the questionnaire, this was Germany, and 3 other countries proposed informal interviews which took place. So without the comparable data from most of the countries covered, the methodology had to be adapted and was based mainly on the desk research, based mainly on the studies of the European Migration Network, EMN, as they also provide information coming directly from the member states. And this information was updated, detailed, and completed by interviews with civil society organizations from member states. So this was about the methodology, and some of the resources that you referred to were included in the study. Quickly about the entry ban. Entry ban in itself won't prevent the person from returning. Actually, most of the people returned from the EU are coming from the countries which need visa. So basically, even without entry ban, most of the people won't be able to return to the EU illegally. What the entry ban, which would imply, is that they cannot even apply for visa. So basically, entry ban would reduce the possibility of returning legally to the EU and not irregular migration. So this was about entry ban, and let me very briefly address the question of ex officio examination. Ex officio meaning at least starting the procedure, at least giving the person opportunity to express fear of being returned to the country of origin or another country. Otherwise, the person would be subject to the return process and would need to appeal the return decision in order to let the person's consent heard. And this is neither protective nor efficient use of resources. Instead of having this procedure done ex officio earlier at the initial stage of the return. And about the asylum system, of course, it's a very good basis. However, the scope of protection under the refugee status and subsidiary protection status is narrower than the absolute protection of refoulement, because it's not subject to exclusion or exception grants under international and EU law. Thank you very much.
Thank you, Madam Metzer. Now, I would pass the floor to the Commission, but before I just be noted that there are 2 members connected from afar, that would like to say a word on the matter? Can you make it in 1 minute? Please, Mrs. Sippel, Frau Sippel, the floor goes to you. Are you connected? Can you make it in 1 minute, please? Frau Sippel? Nope. Yes, she's connected. Are you connected? Birgit? Is she trying to? No? Then how about Madame Keller? Madame Keller, vous avez la parole, 1 minute. Madame Keller, vous êtes là?
Oui, merci, Monsieur le Président. Je voudrais féliciter Tineke Strik pour son rapport vraiment intéressant. Beaucoup d'informations aussi dans l'étude de l'EPRS, où on voit les lacunes considérables de la politique de retour. En France, on estime qu'environ 10% des retours sont réalisés, avec tous les obstacles décrits dans le rapport, obstacles pratiques, juridiques, politiques, géopolitiques. Mais cette défaillance impacte énormément le bon fonctionnement de la politique européenne d'asile dans son ensemble. J'aimerais, cher Tineke, que ce soit peut-être plus souligné dans ton rapport, parce que moi qui ai en charge le règlement de Dublin, je vois bien que c'est le sujet pour les personnes considérées comme non éligibles à l'asile, et quand leur décision de retour n'est pas exécutée, ils redemandent une nouvelle fois l'asile. Donc cela crée des flux dans les procédures Dublin et des mouvements secondaires. Cela permettrait aussi de limiter les situations de non-droit, les personnes qui ne sont pas reconduites, qui restent en fait sur nos territoires. Mais c'est terrible, ce sont des ombres, des personnes qui sont dans une très grande précarité. Donc comme la rapporteure, je voudrais souligner l'importance des retours volontaires, de l'accompagnement de la stratégie qui pourrait être défendue par le Parlement, notamment dans le cadre du nouveau paquet asile. Je vous remercie.
Merci, Madame Keller. Now, we hear from the Commission real short. Señor Castelu, estamos retrasados. Señor Castelu está conectado. Es the head of the Return Policy Unit of the Commission. Are you connected? Señor Castelu?
Yes, hello. Good morning. Yes. So
Yes, please.
Yes, I will just make an intervention. Will be short, but that is necessary because we believe that the report would have benefited maybe from a robust exchange of views in the Commission ahead of the publication, in our view, and we extend this invitation to have a discussion, exchange of views on the technical details of the report with the research section of the Parliament as well as with the rapporteur, if they are available. I wanted to say as well, I will touch upon a number of points have been raised by the honorary members. One is the return rate. Return rate is one indicator. It's not the only indicator, and certainly is not the only indicator the Commission takes when analysing the situation of return and return implementation of the return policy in the member states. We look at quantitative and qualitative data, and many of them. I also want to underline that you all know, and the Commissioner Avramopoulos already declared to this chamber why we did not present an impact assessment for the recast directive. This does not mean, actually means the opposite. The Commission continuously evaluate evidence and evidence-based assessment of the member states' implementation of the return policy through our Schengen evaluations. We do it regularly and intensively. And we have evidence there that actually contests in a number of areas what this report is saying. We shared some of the issues, of course, that the rapporteur is putting forward. For example, the primacy of voluntary return and the importance of effective alternatives to detention, as well as to ensure a proper monitoring system. This is for sure aspects that we need to promote further for the next years, because as many rapporteurs and shadow rapporteurs said today, return will become the most probably important issue in migration management in the next years as well, to ensure the asylum system works properly. On voluntary returns, our observation is based on evidence that the voluntary deferred period is often actually insufficient, but it is not shortened automatically. On the contrary, sometimes it's extended, and actually this leads to risk of absconding during the voluntary departure, which actually undermines the concept of voluntary departure. So, although we are working on reinforcing the voluntary return system, we don't believe the duration itself is a problem, except for actually sometimes it's extended and it also leads to absconding. On the non-refoulement, which is actually one of the main elements of the return directive, as you know very well, the directive obliges member states to respect the principle of non-refoulement at all stages. Some member states actually look at it 4 or 5 times, which is actually excessive. So I do not think the respect of non-refoulement is a problem of the return directive at all. We don't believe there's a protection gap because not all appeals are automatically suspensive. This is not corroborated by observed practice, neither by the jurisprudence of the Luxembourg and Strasbourg courts, which actually say the opposite. In fact, just to come into the second point of non-refoulement, 16 member states that issue a return decision together with an asylum decision, the appeal always stops return procedures, always. And in the remaining others, these other remaining 11 member states, suspension is either granted automatically or on request, always ensuring automatic protection against non-refoulement. And I would like to underline this principle because it is fundamental, as the honorary members say. What happened is that due to weak links between asylum and return, returnees have several possibilities to frustrate return, which is actually bad for the overall functioning of the return system, and therefore as well weakening it and weakening our overall migration management system. What they do is lodge several appeals with an automatic suspensive effect or make subsequent unfounded asylum applications, and we are trying to fix these loopholes. On the entry ban, I think Mr. Branchel was very eloquent in the way he presented the point, and I think he is right. The entry bans are there indeed to avoid what it seems that Mrs. Strick was proposing, that people actually come in and come out from the EU. Obviously, the entry ban is there that for someone who was staying illegally in the EU territory, cannot return. Having said that, of course, the timing of the entry ban and things how it has to be applied, of course, is something debatable that we can discuss. And then finally, Mr. Chairman, on the risk of absconding, because I think it's also a very important point raised by the honorary members. So we cannot agree that member states apply the risk of absconding indiscriminately. We, of course, want to reinforce and strengthen, as the rapporteur says, the effective alternatives to detention. However, we repeat, member states do not apply absconding criteria indiscriminately according to our evaluations. We cannot support either the claim that member states order detention for the maximum period set out in the legislation to avoid reviews. On the contrary, member states review in generally detention, take detention as a last resort and very seriously, and to our evidence knowledge, the majority of member states ensure a judicial review of detention at maximum 3 months. Whether actually to have a shorter or longer period of detention is more or less effective for returns, again, is debatable, and we're happy to exchange thoughts with the rapporteur and the research service of the Parliament on this, but the reality at the moment shows that member states are using detention in a proportionate manner. Then I think I will just finish with this point, not to extend the discussion. Simply, I want to conclude, of course, that we look forward now to continue working with the rapporteur and would remain available to provide additional information and evidence. We also look forward to resuming work on the report on the legislative proposal itself, because I think now, of course, becomes urgent that we engage on this and we have a proper discussion. Thank you.
Okay, thank you. Now, please, if you may make a fast conclusion. I thank you for that, because we still have to hear from Director of Frontex on the same matter, on return policies. The floor is yours, Mrs. Strick.
Thanks to the shadows and others who have contributed to this discussion. First, I need to answer a few remarks made by Mr. Rangel. First, I really think actually, to be honest, it doesn't suit you that you offend the researcher for having her conclusions already ready before she starts her research. You must know that this is the most serious allegation you can utter towards a researcher, and that really touches upon her integrity. And I really hope that you are not doing that seriously. She did a tremendous job in very difficult circumstances, because a lot of information was not very easy accessible. And I think, of course, we have different opinions, we may have different ideology, but let's not be blinded by that ideology. Let's really look at the reality. I think we have a common ground that we all want to have an effective return policy in Europe. I mean, there's no difference about that. But the point is that we really need to look at what instruments are effective and do we really apply them in the most effective way and within the framework of the procedural safeguards and the principle of proportionality. This is one package. And then if you look at the voluntary return, it's also confirmed by the Commission that needs to be the priority. And then if you look at the frequent application of the derogations from this voluntary return, that means that many people do not have the chance to leave the country voluntariness. And that indeed what also was mentioned by some shadows is that this also touches upon the sustainability of that return. Voluntary return is more sustainable than forced return. So therefore we should do everything we can to make that happen. Therefore offer terms, invest in programs, so supporting voluntary return, and especially what this report touches upon is the fact that a number of member states already impose an entry ban while there is a voluntary departure term. And that is really rendering it ineffective because it's meant as a stick in order to comply with the voluntary departure term. But if you already get this stick before you can comply, why should you still comply with it? So it's meant as an incentive and not as a sanction. And then also regarding detention, the point is that we really need to make it a last resort, and therefore we need to make effective alternatives much more available and useful. And there we could really do a lot more with the Commission and the European Parliament, and also make sure that the detention is as short as possible, because indeed many studies show that the longer the detention takes, the less effective effect it actually renders. And then one of my last points is Article 6, paragraph 4, the possibility to grant residence rights for people who cannot be returned. It's in many legislation, but it's not applied often, and this also makes the return directive less effective because the whole objective is also to avoid irregular migrants. Or if they are irregular, they need to be returned. If they cannot be returned, we need to find another solution for them. Otherwise, we are still, we keep a big number of migrants without any rights, without any perspective, and this is harming all parties involved. Then my last point is towards the Commission. I'm really a bit surprised that the Commission now comes with saying, look, we should have turned to the Commission for exchanging views. We asked many times for more information on the implementation. Actually, we reminded the Commission of the legal obligation to come up with its own reports. And now discrediting this, debating the conclusions in this report, it's really a missed opportunity, I would say, of the Commission. But nevertheless, we are very much open to the information that you apparently have, but did not make transparent until now, to share that with us so we can have a better, even a better evidence-based policy-making contribution. Thank you.
We thank you, Mrs. Strick, for that concluding remark. And now we move to a point which is much related to this one, because we are waiting for the presentation by Ana Cristina Jorge, which is Director of Operational Division of Frontex Agency, the European Border and Coast Guard Agency. With no further delay, because we had scheduled this morning session up until 10:30 and we are lagging behind, that is obvious. We hear from you, Señora Jorge. Mrs. Jorge, are you there, connected? Yes, you are.
Good morning, can you hear me?
Yes, we can hear you. The floor is yours.
Thank you very much. Thank you, first of all, to give the opportunity to Frontex to present this second semester 2019 report on return operations. As you know, this is an obligation coming from the last regulation that entered into force in December, but every 6 months for some years that Frontex has been producing these reports and presenting them to the management board. I have now the privilege also to present it to the members of the European Parliament. I would like to start with the statement. So this report does not present a general overview of all returns in the EU, as it does not cover return operations carried out by member states on national levels without the support of the agency. The purpose of this report is to provide a comprehensive comparative analysis of the results of Frontex coordinated return operations carried out between the 1st of July and the 31st of December 2019, together with the observations of the Fundamental Rights Officer, with a view to enhancing the quality, coherence and effectiveness of the future return operations. As you know, the agencies does not enter into the merits of the return decisions issued by the member state authorities, and its role is to provide technical assistance and operational coordination, which may consist of optimizing the resources at European level by matching needs and requests provided by different member states with the aim to organize joint return operations with the participation of 2 or more member states, providing technical assistance by chartering aircrafts, booking and ticketing returnees and staff on scheduled flights, organizing support of forced return escorts for the return pool when it's needed and requested, and the presence of Frontex representatives on board. Supporting and monitoring fundamental rights through the use of the pool of force monitors, providing an implementation plan that sets the rules and details regulating the operation in line with the applicable legislation, generally fostering communication and joint approach to return across the EU and financing the return operations. The agency successfully managed to provide member states with a wide range of services, including the possibility to implement return operations to more countries of return than in previous semesters. Besides providing human resources to requesting member states, the agency continued to expand its technical support offered to member states by chartering aircraft for return and readmission operations. In order to strengthen the return-related communication between the agency and member states, Frontex was continuously involved in organizing meetings that provide a basis for dialogue, as well as exchange of operational feedback aimed at improving the overall efficiency of return operations. The agency provided also assistance by offering consultancies and dedicated training sessions, actively sharing best practices and experiences gained. This report covers return operations both by chartered and scheduled flights, as well as readmission operations from Greece hotspots to Turkey within the EU-Turkey statement. Return operations by chartered flights were carried out by means of airplanes chartered either by member states or directly by Frontex, while the return operations via scheduled flights were carried out on regular commercial flights. Return operations by chartered flights include also collecting return operations from which the means of transport and forced return escorts are provided by the country of return. A total of 8,233 non-EU nationals were returned by member states with the support of Frontex, 75% in operations by chartered flight, 32% by scheduled flight, and only 1.5% correspond to readmitted to Turkey from Greece. The total number of returnees increased by 8% in comparison with the previous semester, mainly due to the growing support to returns by scheduled flights. On the monitoring of return operations, 168 monitors took part in return operations coordinated by the agency, 91 of which from the Frontex pool of forced return monitors deployed upon member states' request. As a result, at least one monitor was present on board on 122 out of the 167 Frontex coordinated return operations. And what we ensure is that when it's a collecting return flight or a Frontex chartered flight, then 100% of these flights are covered with presence of monitors on board. The main challenges that we faced during this period, the high share of national return operations versus the joint return operations. The agency continuously promoted and monitored cost effectiveness of return operations and sound management of availability seats on chartered flights. However, ensuring sufficient efficiency of such return operations was not always possible. The report highlights that in over 2/3 of the chartered flight operations, the returnees were just from one member state, despite the higher overall effectiveness of joint return operations that generally ensures a higher number of returnees in a lower number of flights. Optimization and efficiency would require adjustments in some member states' policies and procedures, both from perspective of willingness to join their efforts instead of operating on national level, as well as looking into joint return operations as a more efficient tool also to better tackle last-minute cancellations. Member states are constantly encouraged to open operations to the participation of other member states when allowed by the countries of return, as well as to participate in operations organized by others instead of organizing their own, and also to organize operations with multiple destinations in order to widen the offer to other member states and optimize the use of available seats and frequency of flights towards some geographical areas. Sometimes member states inform Frontex about their needs and plans only at short notice or did not provide sufficient information on return operations organized at national level. This considerably hampered the operational capacity of the agency to efficiently plan the operational activity and often led to possible overlaps of operations to the same destinations in same periods, having in some cases potential prejudicial effects in relations which exist between the EU arrangements with certain non-EU countries. In line with the existing EU legal framework, some procedures and practices in operations coordinated by Frontex differ from those regularly implemented by member states. We have dedicated codes of conduct for participating member states, the monitor's obligation to report to Frontex, we have a complaint mechanism for fundamental rights and other instruments. This lack of harmonization of operational procedures, which is often perceived by member states as an additional burden, and in some cases also we face language barriers that hindered a more extensive cooperation between the member states and Frontex. Also, we noticed an underutilization of the return pools. Member states are encouraged to make use of the Frontex pool.
Please, señora Jorge, por favor. Señora Jorge, por favor, ¿puede wrap up, puede sintetizar para ayudarnos a sostener el debate antes de que concluya la sesión, por favor?
Yeah, I'm just finishing. So we are talking about the better use of the Frontex pools on return and on escorts, which could be better used by the member states. And I would like to finalize just to mention that the observations of the Fundamental Rights Officer have been formulated in 10 areas and included an overview of the findings and conclusions from 127 reports submitted by the forced return monitors deployed from the pool and 6 reports from national monitors. A major part of the monitoring report findings identified the return operations to be undertaken in a proper manner and in respect for fundamental rights. So I will stop here and I'm available at the end if there is a need to reply to any questions. Thank you.
Thank you. Thank you for the presentation on the return policy and the operations conducted by Frontex. Let's hear now from the members, which are listed. I understand for the EPP, it'll be Mr. Rangel or Mr. Tobé. Is it Rangel? Yes. Okay. Yours.
Thank you very much, Mrs. Ana Cristina Jorge. Bom dia e obrigado. The role of Frontex is clear that is crucial. Ensuring safe external borders. But I wouldn't say it's not only this main goal. Frontex is key in promoting other forms of solidarity and cooperation, and naturally that implies carrying operations of return. And despite recent changes in your legal basis, it is clear that much can still be improved. despite observing, I'd say, an increase in the last 3 semesters, it is clear that Frontex has supported a small percentage, a small portion of the returns carried out in the European Union. My question is, in your view, why are the member states still so reluctant in using the capabilities of Frontex? I also would note that you have referred that cooperation is very much hindered by administrative and logistical burdens. Would you not agree that cooperation could benefit if member states were to develop, in cooperation with Frontex, systems connected to the agency in order to manage returns? Wouldn't return be more effective and I'd say even more according with the rule of law and the protection of humanitarian patterns if it was managed in a major part by Frontex? So the involvement of Frontex could be here a condition for more effectiveness and also more protection of human rights and our, I'd say, values. Thank you.
Mr. Rangel. Madame Guillaume, vous avez la parole.
Oui, rapidement, d'abord pour indiquer que c'est un très gros volume d'informations qui nous est communiqué, sur lequel il faut, je crois, se pencher de façon très sérieuse. Cette discussion fait écho à ce qu'on a indiqué tout à l'heure et les éléments de discussion reliés à la présentation par Tineke. Il y a un sujet sur lequel j'aimerais peut-être entendre Frontex, à qui on continue de demander beaucoup, toujours plus, y compris sur des rôles qui ne sont pas nécessairement les plus importants en termes de pourcentage de son activité. Mais ma question poserait autour de la coopération. On a vu tout à l'heure dans les éléments de débat sur le rapport de Mme Strick que la question de la coopération entre les États membres, ou en tout cas les distinctions sur les modes de fonctionnement étaient assez importantes. Et là aussi, est-ce qu'on aurait des éléments plus précis sur cette coopération, plus exactement le manque de coopération entre les États membres, Monsieur le Président?
See, now it's Mrs. Intveld for Renew.
Well, I can be very brief because, first of all, I would like to echo what has been said basically both by Mr. Rangel and Mrs. Guillaume about the role of the member states and the lack of support. But the second question, I heard you mention, Mrs. Jorge, the fundamental rights complaints mechanism. And we have seen in the past that doesn't actually function properly because the complaints have to be addressed to the national authorities, and then Frontex is not always made aware of the fact that such complaints have been submitted. So can you say a little bit, I mean, we've asked that question in the context of other activities of Frontex, but I feel when it comes to returns, but also if we see the current scenes on the borders, I would like to hear a little bit more about that. But like Mrs. Guillaume, I'd also like to get a bit more, let's say, of all the figures we just heard, there was a lot there. Could we please get that in writing?
For the Greens, it'll be Mrs. Strick.
Thank you very much for your presentation. I have one question on voluntary returns. I know that Frontex is now gradually enforcing its capacity to invest in voluntary return. With which member states are you going to cooperate on that? And what's the state of play regarding the capacity on that? Then regarding fundamental rights, Frontex is not allowed to work in areas where fundamental rights are being violated. Are there any areas at the borders of the EU where Frontex, for that reason, is not physically operative? Are there any parts of countries where Frontex says we don't want to be involved? And in what way does Frontex have influence on if there is a threat of violation of fundamental rights to make sure that member states do behave and do not do stop those violations? And regarding, well, you mentioned the numbers of incidents reports and complaints, that it all has been assessed. But on the other hand, we know that from observations of the Fundamental Rights Officer in 2019, she expresses in her observation concerns on the force, on the use of force, and also on incidents where Frontex allows member states to use force, like the use of dogs, of pepper spray, etc. Can you explain a little bit on how this is reconcilable and what Frontex is really doing in those situations? And what is the current state of play regarding the Fundamental Rights Officer job position? Is it still open? Is there a vacancy? What is happening? I mean, it's pretty intransparent for us, but something seems to be going on. And what's the state of play regarding the acquisition of the 40 monitors, the fundamental rights monitors that are being established in the latest Frontex regulation? Thank you.
Thank you, Ms. Strick. For ECR, Mrs. Kempa.
Bardzo dziękuję, Pani Przewodnicząca. Dziękuję za te informacje. Śledzę też działalność absolutnie bardzo dobrą Frontexu, ale wciąż i wracamy tutaj też w nawiązaniu do poprzedniego punktu, one się wiążą ze sobą. Jednak głównym narzędziem tutaj jest dyrektywa powrotowa i powrót do procedowania nad tą dyrektywą jest naprawdę jak najbardziej wskazany. My w zakresie treści jako EKR popieramy ustanowienie przyspieszonej procedury granicznej w stosunku do osób, których wnioski zostały przede wszystkim odrzucone. Musi być usprawnienie komunikacji pomiędzy instytucjami i urzędami. To już tutaj padło. Między innymi również usprawnienie komunikacji pomiędzy Frontexem a innymi urzędami. Usprawnienie procedury odwoławczej, przyspieszenie procedury dotyczącej wydawania decyzji odmownych, zwiększenie efektywności powrotów dobrowolnych, o tym też szerzej dzisiaj mówiliśmy, zwiększenie efektywności, ustanowienie systemu zarządzania powrotami w takim celu, aby zapewnić dostępność aktualnych informacji na temat tożsamości, sytuacji prawnej wszystkich osób, co do których wydano decyzję o powrocie. Oczywiście szczegóły będziemy też uwzględniać w poprawkach, ale po raz kolejny w tym punkcie ujawnia się wielka potrzeba nowelizacji tego dokumentu, który jest kluczowy w tej sprawie, o której dyskutujemy. Dziękuję.
Thank you. For the GUE, Madame Pelletier, vous avez la parole.
Merci, Monsieur le Président. Merci à je recommence. Merci beaucoup à Frontex d'être venu aujourd'hui. Que d'informations, et notre collègue du PPE va être ravi, c'était quantitatif. Passons. En février, Frontex a déclaré que le montant de son budget déterminera les activités qu'elle sera en mesure de mener en matière de retour et comment l'agence compte-t-elle s'assurer et soutenir l'intégration des personnes faisant l'objet d'une décision de retour, afin d'éviter que l'agence ne participe à des opérations qui pourraient mettre en danger finalement des personnes faisant l'objet de ce retour. Ma deuxième question sera la suivante. Le Forum consultatif de Frontex a recommandé que l'agence ne soutienne pas des opérations de retour de Hongrie du fait de l'obligation de l'agence de retirer son soutien à des opérations où des droits fondamentaux ne sont pas respectés. Alors, est-ce que Frontex a mis fin à son soutien aux opérations de retour en Hongrie? Sinon, pourquoi et comment garantir que cette coopération avec la Hongrie ne mette pas l'agence en danger d'être complice d'activités pouvant violer les droits fondamentaux? Merci.
Thank you. That has been a sharp series of questions. Maybe we hear back from Mrs. Jorge, Director of Frontex, Operational Division. Maybe you would react. to the comments and direct questions that have been raised by the members. The floor goes to you back.
Thank you very much for giving me the possibility to react. There were areas here that are not really within the report on return, but I will try nevertheless to touch upon all of them. So how do we better cooperate with the member states and the creation of systems managed by the agency that could streamline this cooperation? Indeed, the agency promotes many meetings, many groups of work in order to put the member states together and discuss the needs and the possibilities to further cooperation. When it comes to systems, we developed several systems to manage return, and they are being now further developed. We just 1.5 years ago, we inherited the system that was developed by the Commission for the overall management of return in Europe, and this is a system that we are using as a platform in the future so that the agency can in fact manage systems that member states can use to better exchange information and better cooperate in the future when it comes to the promotion and the implementation of the return. So, as I was mentioned in the report, we mentioned several aspects related with a need for a stronger cooperation. This has to do with some internal regulations and rules that are in place in different member states that are not harmonized. And here the agency does a lot of work in order to, together with the member states, find the best practices, the best procedures. We developed a system that is to be used by the member states. It's a return case management system that we are helping member states to implement at national level so that they also harmonized at national level and between themselves the return procedures in order to facilitate the future cooperation. When it comes to the implementation of the new regulation in different aspects of the return, we have a roadmap that was established with the Commission and that is also followed by our management board. We are now in the phase where we are preparing also the takeover of some return and post-return programs that were developed by member states in Europe. But at this point, we still don't have a project developed with specific member states in order to initiate voluntary return. So we are still work ongoing. Violation of fundamental rights and complaint mechanism. We have in place systems, so procedures in place that are very effective. So when we have operations with member states or in the territory of member states with deployment of officers, we have a serious incident report mechanism in place. Then whenever fundamental rights are not followed, the officers are obliged to report to the agency. And if it is a fundamental rights violation or possible violation, the coordination of the follow-up procedures is by our fundamental rights officer. And therefore, we are aware of if these situations happen during our operational activities. The complaints mechanism that we have in place, that is also in charge by the fundamental rights, it's a complaint system where the complaints go directly to our fundamental rights office. They don't go through the member states and then channeled to the fundamental rights officer. The system is established in a way that there are different ways that communication can be done, but it goes really directly to our fundamental rights officer. And, well, again, in all aspects related to respect and monitoring of the fundamental rights, no matter what activities at the external border or with return, the serious incident report is in place, is obligatory. If the situation is repeating and there is a need for the agency to assess, so we first cooperate with the member state by identifying the situations and requesting that these situations are not repeated or are corrected. But the regulation also allows the executive director to suspend or terminate any kind of operational activity in a member state if there are serious concerns related to the respect of fundamental rights. I stop here. Thank you.
Thank you. We thank you for your contributions and your efforts to respond to the direct questions that were made. And we thank you all. We have, I guess, we have heard every floor that was requested. No other members in the list, and we thank this last round of contributions for having helped us to catch up and made it right in time, because we made it right in time. So we thank you all. I'm only to announce that we had a vote this morning. It was a Tardino report on the law enforcement cooperation agreement between the European Union and New Zealand. And the draft report has been adopted. I'm announcing that there has been a result of 37 votes in favor, 26 against, and 2 abstentions. So it's been adopted. And I'm only announcing that we will resuming our work next week, July the 6th at 9 a.m. We will be having an extraordinary session of the LIBE Committee, okay? Here in Brussels. Thank you all. Have a nice weekend. Thank you.